Good morning.
Good morning. May it please the court. I'm Justin Strother, and I represent the appellant and relator Joshua Harman in this qui tam suit. I'd like to reserve 5 minutes for rebuttal, please.
5 minutes, certainly.
Your Honors, there is one issue before the court today, and it is straightforward. Did Joshua Harman adequately plead his Tennessee False Claims Act cause of action? Appellant asserts that he did, and accordingly, the lower court's order dismissing his cause of action for failure to state a claim should be reversed. There are lots of issues surrounding that core issue, and both appellant and appellee spent some time in their briefing going over them. However, the core issue is straightforward, and so I would like to focus today on two main issues. Number one, how did Joshua Harman satisfy Rule 8? How did he plead the requirements of the Tennessee False Claims Act? Number two, I'd like to spend a little time discussing the trial court's erroneous use of collateral estoppel to bring in extraneous facts to support its order dismissing Mr. Harman's claims. The Tennessee False Claims Act has two components that Mr. Harman must plead, and I would like to take a moment and focus on the fact that today the court is reviewing Mr. Harman's complaint de novo, assuming that all of the facts pled are true, affording Mr. Harman all of the reasonable inferences, and additionally, not looking outside of the pleading. This is a motion to dismiss rather than a motion for summary judgment. The trial court did not take the opportunity to convert the motion to dismiss into a motion for summary judgment, which it could have. So using the de novo standard to scrutinize Mr. Harman's complaint, this court should be looking for two things. Did Mr. Harman plead a misrepresentation? And did he plead knowledge on behalf of the appellee Trinity? By the way, there are two entities that I refer to collectively as Trinity. That's been done throughout the case, including in the pleadings and motions to dismiss. That shouldn't be a complicated endeavor. And so the first thing I would like to do is actually call this court's attention to three of the many misrepresentations that Mr. Harman pled in his Second Amendment complaint. And I'll provide the court the page and volume from the lower court's record. The first and I think most obvious example of a misrepresentation is in paragraph 8 and also in paragraph 35 of Mr. Harman's Second Amendment complaint. This is in volume 41, page 5359. Quote, "With each sale and installation of the secretly modified ET Plus, Trinity falsely certified and caused highway contractors to falsely certify to the state of Tennessee that the altered end terminal system was identical in design to the original approved design." So I'd like to deviate from my course for one moment and remind the court what it is we're complaining about, what the change was and what the mistruth actually was.
Before you go there, you said the question for us is, did your client plead misrepresentation and knowledge? What you just read to us, I believe, would constitute a conclusory statement as distinguished from a statement of fact. Are there other facts in the complaint that build a foundation for that conclusory statement?
Yes, Your Honor. So I think there are two ways to answer the question with additional information. One is to point out that the Second Amendment complaint goes through explicit detail about the facts underlying that allegation. And those are these. When Trinity has asserted that to put this product on the Tennessee roadways, it has to do one thing, and that is certify that the product is Report 350 compliant. Report 350 is a document that lines out how to crash test devices that are going to be placed on roadways, the conditions of the testing, the data that needs to be collected, etc. Trinity's incorrect about that. The Second Amendment complaint goes into detail about what Trinity actually had to do, and what Trinity actually did was apply to the state of Tennessee for approval. And in doing so, it made several representations to the state of Tennessee. Number one, it provided specifications of the product. Number two, it provided drawings of the product, which point out the very important physical criteria of the product. And also, number three, it provided an actual physical specimen the actual guardrail terminal that was going to be used. This had among other important details, it had a 5-inch feeder chute. It received approval from the state of Tennessee, the Tennessee Department of Transportation, in 2003. And an official letter was created that said, Trinity, we approve of this product. You may not substitute it with anything else, and any changes you have to supply the drawings of. So those are the basic facts that underlie that misrepresentation.
And that was based upon the 5-inch design.
Yes, Your Honor. Yes, Your Honor. In 2005, Trinity changed it to a 4-inch design, which was ultimately tested in 2015. The state of Virginia paid for independent testing as opposed to having Trinity test it, and it failed the Report 350 criteria. It is not safe on the roads, and the chief engineer in Virginia said, this poses a serious danger to roadway motorists. And Virginia went ahead and removed it from the roadways and has begun replacing it. In the state of Tennessee, after the need for additional testing was noticed, the state of Tennessee took it off of Tennessee's qualified product list, obviously showing that this was indeed a material misrepresentation made to the state of Tennessee.
Is materiality a requirement under Tennessee law?
It's not, Your Honor. I can understand why that's an academically interesting question, and we are certainly on the side of saying it most certainly is not a requirement. The stronger argument may be that we pled it in any case, and it is material. I was about to say that the city of Nashville has gone ahead and removed them from Nashville's roadways. So the idea that somehow pulling the wool over the state's eyes, getting an unsafe product on the road that once it's learned about, the state, or especially the city of Nashville, has gone ahead and rectified the problem, smacks of materialness.
Counsel, I'm trying to figure out what's fair game in terms of consideration with regard to this motion to dismiss and assessing it. Public records. Public records in terms of consideration, a good deal of what's being addressed here could fall within the domain of a public record, federal administrative agency reports. Is that fair game without converting this case into one that should have been considered for summary judgment rather than a motion to dismiss?
Your Honor, I believe that that's probably a sliding scale. What a trial court in a motion to dismiss may take judicial notice of appears to be, unfortunately, a slightly wobbly standard. So can laws be considered by the court? I think that we would concede they could. Can internal memorandums of a federal agency that have nothing to do with the state of Tennessee be considered? We would say no. Other public records, I think it would depend upon what the records actually are.
Are there particular documents that were considered in this case that you would point to and say that was over the line? That was regulation is fair game, but this was over the line, this aspect of this federal highway authority report? Or are there particular documents that you would reference us to as that was a problem for considering it?
Yes, Your Honor. Trinity pointed the trial court to items on the Federal Highway Works Administration website, like a frequently asked question type document about the ET+. We think that the trial court should not have considered that. However, we don't think it makes a difference when this court actually looks into the significance of those. All of the Federal Highway Works Administration is not the final arbiter of what goes on the Tennessee roadways, and the Federal Highway Works Administration acknowledges that. Tennessee is the decider of what goes on these roadways. It decides whether to purchase things. There is a lot of hay made in the Appellee's briefing about, and certainly in the lower courts, consideration of the Fifth Circuit opinion and the unrelated Harman versus Trinity matter. They have the same party names, but there was only one detail in that, and this, I'm going into collateral estoppel real fast. There was only one detail in that case that the Fifth Circuit actually held. Everything else, it expressly said, this is dicta. We're not actually finding these things, we're just discussing them. So under the rules of collateral estoppel, they can only, Tennessee may only consider one element of that opinion, and that was whether the misrepresentations made by Trinity to the FHWA were material to the FHWA's payment behavior. That's not an issue at all in this case. The issue in this case is were the misrepresentations that were made to the state of Tennessee impactful to the state of Tennessee's decision. So to answer your question, Your Honor, they probably shouldn't have been considered, but more importantly, they shouldn't make a difference. Returning to the misrepresentations, there were at least two more obvious examples of misrepresentations made. This is in paragraph 40 of the amended complaint on page 5369 of the record. Trinity affirmatively attempted to deceive its regulators and customers by giving the 4-inch ET Plus end terminal the same product number and name as the discontinued 5-inch ET Plus. Our point there is you can't go through the approval process, have the state of Tennessee, Your Honor, may I conclude this thought?
Please.
Can't add the 5-inch ET Plus to the Tennessee qualified products list, essentially creating a glossary for terms within the state of Tennessee and say, okay, this is the ET Plus. 2 years later, change it into something else and say, oh, but we're not lying. We've just used the same name. So I'll reserve the remainder for rebuttal.
All right, thank you. We'll now hear from Mr. Cooper. Good morning, sir.
Good morning, Your Honors. May it please the Court, Bob Cooper of the Nashville Bar, here on behalf of Appellee's Trinity Industries and Trinity Highway Products. This Court should affirm the judgment below. The trial court properly dismissed Harman's second amended complaint because it did not plead falsity, knowledge, or materiality sufficiently to state a claim under the Tennessee False Claims Act. Harman's original claim, if we go way back 8 years, was that Trinity falsely certified that the ET Plus, its guardrail in terminal product, complied with national crash test standards under NCHRP Report 350. But that certification was true because the ET Plus had a, quote, unbroken chain, close quote, of Report 350 approval from the Federal Highway Administration, which Tennessee and other states rely upon to make those judgments. Now that is the core of this lawsuit, Your Honors, and everything else that Harman argues, to borrow a phrase, is much ado about nothing. Now, it's interesting that we didn't hear anything about what was the sole predicate for plaintiff's second amended complaint, which was an email chain from 2005 that they claim is a smoking gun and in fact is just a smoke screen because it had nothing to do with the ET Plus. It had to do with a different item, an ET flared, and TDOT did not use flared end terminals on state highways. It only used tangential end terminals, and that's in their QPL, the Qualified Products List, that's in their SOP, and in their standard drawings. And furthermore, the crash test data, they've pointed to no obligation to have disclosed this email, or the crash test data that it discussed. And then finally, Harman presented this crash test data at his 2014 federal trial in Texas. And the FHWA had the data when it reaffirmed the ET Plus as Report 350 compliant in 2015. So again, these emails are irrelevant to this case, as the trial court correctly found.
Counsel, isn't the falsity here contained in the idea that we have Trinity providing a product it's safe, it works, the state wants to purchase it, and they alter it without letting the state of Tennessee know that the product has changed. And the Harman suggests that it is an unsafe product, that increased the risks. And so the state of Tennessee has been purchasing guardrails that are less safe, that they did not know were less safe. And none of this may be true, but for purposes of motion to dismiss, isn't that an adequate claim?
No, Your Honor. They have not pointed toward any requirement at TDOT to make such a disclosure. Manufacturers make minor modifications to products all the time. The core of the product was the same. And the point is here, Your Honor, that TDOT relies upon the Federal Highway Administration to determine Report 350 compliance. That's what it says in their specifications, that all guardrail safety end treatment systems shall require certification from the supplier that the device is an NCHRP 350 approved product documented in an acceptance letter from the FHWA. And then from their QPL in 2004, a completed product evaluation form, MSDS sheets, if applicable, product data information, including letter from the FHWA stating that the product meets NCHRP 350 guidelines.
When did federal authorities become aware of the change in the product? When did the federal authorities, at what point in time?
In 2012, Your Honor. That is when Harman presented his findings. If I could go back, though, to one other point to your other question, TDOT did not adopt a rule requiring the notification of changes to a product until 2016. And that and you can find that in the 2016 Qualified Products List Forward, where TDOT says that they are requiring a certified letter that, quote, no changes have been made to the product since the original product evaluation submittal, close quote. So prior to that time, there was no such rule, and therefore no required certification, and therefore nothing that Trinity could have falsely certified. So I'm sorry, Your Honor, your other question that I think.
Just trying to understand the timeline.
Okay, so the timeline, yes, they received this information, the Federal Highway Administration, in 2012, then that, and in fact, Trinity at that point, having been notified by the FHWA that it had been given this information, notified the states about what was going on. So all the states, including Tennessee, were aware of what the dispute was starting in 2012. And then that prompted the FHWA to go back, relook at the crash test data, which they did, and then issued a report on June 17, 2014, stating that get the language here. Well, stating that the ET Plus had been qualified in 2005 when it was first reviewed by the FHWA for use with the 31-inch guardrail.
Was there an obligation to alert federal authorities with regard to the change in the product, that this product was not the same product that originally had been approved?
No, Your Honor. Neither the Report 350 nor FHWA policy required a manufacturer to notify the FHWA of all modifications to roadside safety devices. Report 350, it says that it's not, quote, uncommon for a designer or tester to make design changes, and explains that retesting is needed only if there is a, quote, reasonable uncertainty about the effect of the changes. And then the FHWA, in their eligibility letter request FAQ, said that it did not expect submitters to notify FHWA of non-significant modifications. So the FHWA is obviously the arbiter of that. It got this information in 2012. It re-examined the product and the original crash test data and determined that the ET Plus had always been Report 350 compliant, meaning that it concluded that this notification was not necessary of these minor changes to the product.
Mr. Cooper,
Yes.
with reference to the FHWA requirement that they don't require approval of non-significant modifications, at what point and who decides whether it's significant or non-significant?
Well, that would be the FHWA, Your Honor, because...
But if you don't notify them that a change has been made, how are they triggered to inquire whether it's significant or non-significant?
Well, in fact, Your Honor, they have since changed their rules on this, but at a time period after that at issue in this lawsuit, which is essentially the time period from 2005 to 2014. So they have made some adjustments, but the rule at the time, which is, of course, what was controlling with regard to the certifications that Trinity was making, was that they did not require non-substantial notification of non-substantial changes.
I mean, all this sounds like stuff of summary judgment, not stuff of motion to dismiss.
Well, no, Your Honor, we would say that this is appropriate for a motion to dismiss because what you are dealing with here are issues of law, not issues of fact. The question is, what were the rules that the TDOT had requiring certifications, and were the documents that were submitted by Trinity consistent with those rules. So it's a question of interpreting TDOT standards.
Counsel, following up on Judge McBrayer's question there, I wonder what part of the federal analysis here is fair game for motion to dismiss. At what point are we instead into the land of summary judgment with, it's one thing to look at a regulation. How deep in the administrative state agency report analysis can a trial court go at the motion to dismiss stage before this becomes a matter for summary judgment and not a motion to dismiss?
Well, Your Honor, the point here is that the issues, the plaintiff is a qui tam plaintiff and steps into the shoes of TDOT. TDOT, as we've already discussed, defers to the FHWA to make this determination. So this is not something that a trial court would go behind what FHWA was doing, because TDOT defers to FHWA.
Let's take something, though, for example, that this isn't a significant change because it's not more dangerous, so say the federal authorities in looking at this. That sounds suspiciously like something that would be part of a summary judgment determination rather than a motion to dismiss determination. That's not a regulation. That's a report somewhere, right? That's issued that says this is safe. It's not a problem to have to go on to 4 inches and to have changed the mechanism.
It is a report, Your Honor, but these are reports that are appropriate for a court to rely upon in a 12026 motion. Both parties agree on the rule for what a trial court may consider. Matters attached to or cited in the complaint are integral to the claims, items subject to judicial notice, and matters of public record. Now, in fact, the trial court only cited a handful of extrinsic documents, 8, I believe, and they were mostly state and federal documents, TDOT's SOPs, standard operating procedures, and qualified products list, and FHWA's memorandum, all of which are either cited in the complaint, are integral to the complaint, are subject to public notice, or matters of public record. And then the other thing that the court relied upon were Trinity's certification forms, which are both cited in Harman's complaint and integral to the claim. So, Your Honor, all of that is fair game. The question is, what more does the court need? The question, it's a question of interpretation of what does TDOT's standard operating procedure require.
Is the public record really fair game for all purposes? And it's one thing perhaps to say there's a report that exists versus this product is actually safe because we have federal authorities here having reviewed it. Those don't seem to be exactly the same thing. I mean, public records may be fair game for purposes of motion to dismiss analysis. Can you consider them for that, for example, that factual purpose that this product is a safe product?
Well, let's go, though, back to what is it that Trinity was required to certify. And for that, you look to the TDOT Standard Operating Procedure 6-1, which is the controlling document. It's the specific requirements for guardrail manufacturers and suppliers. And the key language there, if you look at the 2010 version, it's in Section 5, although, frankly, the same language is in all of them. Section 5 requires a certification letter stating that the end terminal is either on the department's qualified products list and/or that it meets NCHRP 350 requirements. And that is what Trinity certified. If you go to the certificate, it says that the ET Plus was, quote, NCHRP Report 350 compliant, close quote. So what Trinity is required to certify is what is the position that the FHWA has taken on this product. And that is a matter of public record. It's not even hearsay. It's a question of did FHWA issue a certificate? Yes, they did. They said this product is 350 compliant. Trinity then reported that to the state. And that's all that the SOP required. And and Harman may disagree with that, but that doesn't make Trinity's certification false. So that issue is pretty straightforward, and that is what the court ruled. Conducting additional discovery is not going to change the fact that FHA made that certification and that Trinity correctly reported it to TDOT. Now, there are other sections that Harman relies upon. Section 2 of SOP 6-1, but it doesn't require any certifications. Or Section 3, which requires certifications about materials. Well, Trinity did provide certifications about materials, the steel, the galvanized metal, the bolts, the nuts, the washers, the cables, all the stuff used to make this product. But that has nothing to do with ET Plus's design. And then again, Harman argues that Trinity falsely certified that the ET Plus as installed was identical to the ET Plus design that TDOT had approved, but TDOT did not require that certification in this time period from 2005 to 2014, which is when the TDOT took it off the QPL. And it was only in 2016 that TDOT said that you had to provide a certified letter that no changes had been made to the product since the original product evaluation submittal. So it's unclear, Your Honor, what purpose would be served by additional discovery here, given what the issues are, which is, was the certification that Trinity made to the state correct? And it was, because this product was certified as Report 350 compliant at all times. There was really nothing more to this case. And that's just talking about falsity, Your Honor. And I'd like to come back, although it doesn't look like I'll have time, to materiality, just to say that, one, that argument has been waived. They did not raise that argument until the reply brief in the Court of Appeals. And so under this court's precedent in Reliant Bank, that argument is waived as untimely. But it's also wrong because the Tennessee False Claims Act is about fraud on state and local government, which is what the Supreme Court said in the Knox County environmental termite case. And fraud in Tennessee has long required a showing of materiality, and that is why it is important here. So, Your Honors, in conclusion, Harman filed this case in June 2014. He has had 8 years to develop this case, to inspect the records, to fashion a claim somewhere within 3 complaints and 2 full briefings. But the question today remains a simple issue of law. What is an objectively reasonable interpretation of TDOT's requirements, and were the certifications consistent with that interpretation? The trial court was correct, the certifications were truthful, and the court's judgment should be affirmed. Thank you, Your Honor.
Thank you, Mr. Cooper. We'll now hear rebuttal.
May it please the court. Appellee's arguments are incorrect about Mr. Harman having 8 years to develop his case. There was a motion to dismiss pending. He's not been able to conduct discovery. And the other suits in other states where he has had that opportunity, he settled in Massachusetts publicly his claims. The state of Virginia, in which he's the key tam plaintiff, has gone ahead and removed the items from the road and has denied the equivalent of the motion to dismiss. Appellee's counsel said that that's all there is to this case. There are litigants, as we've mentioned in our briefing. The state of Missouri had a class action where it settled for $56 million because of this exact kind of fraud committed on the state of Missouri. So this is a real issue. This is not all there is to the case. We are at the motion to dismiss level.
What is the fraud in this case? And factually, what happened here that constitutes fraud?
The misrepresentations to the state of Tennessee by Trinity regarding what it was actually providing to the contractors and installers, when the state of Tennessee was believing that it was getting a 5-inch ET Plus that had been tested and approved. Instead, what it got beginning in 2005 was a 4-inch ET Plus. There were lots of questions posed to Appellee's counsel about the FHWA, and when the FHWA did certain things, there were a couple of moments left out of that timeline. One is in 2014, the FHWA did say, we need to test this further. And that came after the 2012 disclosure by Mr. Harman that there was a alteration to this product. In 2014, that's also when the state of Virginia made additional requests for the the state of Virginia made additional requests. And additional testing was done in 2015. In 2014, that was the same year that the state of Tennessee, upon learning that additional testing was going to be required, said this is now off of our qualified products list. That segues into my rebuttal regarding materiality. I'm okay with that argument being waived. I disagree. It's in our Second Amendment complaint. We make the argument, but we win the materiality argument for the reasons I just said. When the state of Tennessee learned that there was a product out there that was posing a serious danger to motorists on the roadway, they stopped buying it. And they asked for more testing. And when the testing was done, they stopped buying it. And the city of Nashville took it off the roads. That is material. I feel like the arguments that Appellee is making are not the arguments that appear in, or don't have to do with the claims made in Mr. Harman's Second Amendment complaint or our brief. They're the arguments that Trinity just wants to make. Many of them are repeat arguments from the Fifth Circuit opinion regarding the importance of the FHWA and what the FHW did and knew. That's not of critical importance in this case.
Doesn't it impact materiality, though, in terms of if Tennessee is outsourcing its determination of safety to federal authorities, and federal authorities said, this is safe, we think it's fine, ultimately. If that's the purchase procedure that's put in place by the state of Tennessee in terms of signing off on this product, doesn't that defeat materiality there?
No, and Your Honor, I respectfully disagree with the premise and the statement by Appellee's counsel. The state of Tennessee doesn't outsource that decision. That is one component. And it's one way that Trinity could get something Report 350 certified. It's perhaps, it used to be very useful to the state of Tennessee to accept what the FHWA was saying. Not so much anymore. If the court is aware of the law signed into, the act signed into law this year by Governor Lee regarding the Hannah Emers Memorial law, there are new changes to the law to avoid that exact problem. So, Your Honor, I disagree with the premise, but no, I think materiality is, I know materiality as defined by the U.S. Supreme Court in Escobar. Your Honor, may I conclude this thought? I see
Please.
the red light.
Thank you.
Defines materiality as something that would have a natural tendency to impact the government's purchasing behavior. In our case, we're not talking about the federal government's purchasing behavior. We're talking about the state of Tennessee's purchasing behavior, and we don't have to guess. We know that in 2014, the state of Tennessee, because of this change, stopped buying the product. For these reasons, Your Honor, we believe that the lower court's order dismissing Mr. Harman's complaint for failure to state a claim should be reversed. Thank you.
All right. Thank you and Mr. Cooper for your arguments. You've given us a lot to think about. We'll take the matter under advisement. That concludes the morning docket. However, we have other activities scheduled. We have some visitors here from the Nashville Bar Association, and the court has agreed to visit